Welcome to Environmental Law course, dear learner and viewer. In continuation to discussion with Prevention and Control of Pollution Act, we are going to discuss about the Air Prevention and Control of Pollution Act, especially in relation to compliance and enforcement. During the last lecture, we have taken note of the major concept which has been permeated in the Air Prevention and Control of Pollution Act, and we have taken a look of the Air Prevention and Control Pollution Law in colonial perspective and as well as the post-independent India's perspective. And we have tried to assess the basic fundamental that what is the canvas, what is the ambit and scope of the Air Prevention and Control of Pollution Act. Having understood the ambit and scope of the Air Prevention and Control of Pollution Act, now we are moving to the entire strategy of Air Prevention and Control of Pollution Act in having the compliance of the air law, air standards, and how they are going to be enforced. With this, dear learner and viewer, first we will start from the basic perusal of the section 19 of the Air Prevention and Control of Pollution Act in relation to power to declare air pollution control area, which has been heavily seated under section 19 of the Air Prevention and Control of Pollution Act. Section 19 of the Air Prevention and Control of Pollution Act envisages to declare the power have bestowed the power to declare air pollution control area. You may rightly recall in the last lecture we have been discussing the very power and the essence of declaration of the air pollution control area, and we have noted the fact that the declaration of the air pollution control area is a question that can be done with the consultation of the state board. We have highlighted two things in reference to section 19 of the Air Prevention and Control of Pollution Act, saying that this is a very unique provision which has been engrafted into the Air Prevention and Control of Pollution Act 1981, and this provision appears to be and the provision of section 19 appears to be that it is a very salubrious provision, because we do not want we have not seen any kind of such provision in the Water Act or the Environment Protection Act. So the declaration of the air pollution control area expresses and exhibit the intention of the Pollution Control Board in controlling the air pollution in certain locations which might be industrial, and therefore we can say that it has an urban bias or industrial bias in application, whereas on the other hand we see that the air pollution control law is not applicable ipso facto to everywhere and every jurisdiction and every area, like it does not have a kind of a universal application as it has been the case of the water law. What it says that needs to be perused, and what the provision is that the state government may, after consultation with the state board by notification in the official gazette, declare in such manner as may be prescribed by area within the state as air pollution control area, meaning thereby unless and until the state after consultation have officially gazetted the demarcation of the area, the law, the section 19 will not be applicable. While a state government, after consultation of the state board by notification in the official gazette, try to see that any air pollution control area by way of extension or reduction, or declare new air pollution control area which may be merged into one or more. And thus we see that this air pollution control declaration of the area by the state board applies to all kind of any air pollution, meaning thereby that it is likely to cause, or whatever source happens to be, mostly the industrial and the other sources of the air pollution that has not been categorically mentioned in section 19, but by conjecture, analogy and surmise we can submit that The declaration of the air pollution control area happens to be the identification of the area which have a more menacing growth of the air pollution. Having studied the section 19, subclause 1, subclause 2, subclause 3, subclause 4 also talks about that it try to see some kind of an approved appliances installation in that area so that the constant monitoring and assessment of the air quality can be done on the strength of section 19 subclause 4, whereas section 5 subclause section 19 and subclause 5 is very important in the sense that it talks about the burning of the material not being the full in any air pollution control area, and that is a very important provision. And on this provision, in slides to come or in lectures to come, we will be discussing the climate change situation. We will see also the question of stubble burning and how the question of burning of any material which has been condemned under the section 19, or that how the burning of the material other than the fuel are going to be controlled by the declaration of air pollution control area under section 19 in reference to the climate change law, in reference to the stubble burning law, that we'll be going to discuss in slides to come or the lectures to come. In here we can suffice our discussion to say that any discussion on the Air Prevention and Control of Pollution Act 1981 in reference to the compliance and enforcement of the law is heavily dependent on section 19 subclause 1, subclause 2, subclause 3, subclause 4, subclause 5. Having said so, then the other constituent of, as I have been reiterating in the beginning in regard to the air prevention and control of pollution law, that it is not only the industrial, but it is at the same time applied to vehicular pollution. And how it applies to vehicular pollution, section 20 is an important guide which gives power to give instruction to ensuring a standard for emission of the automobile. So, the question of the air pollution out of the industry is number one, and question of air pollution by way of the vehicular pollution or the emission from the automobile has been dealt under section 20, and section 20 envisages that the power to give instruction for ensuring standards for emission from automobile, it say with a view to ensuring a standard for emission for air pollution from automobile laid down by the state board under clause G of subsection 1 of section 17, meaning thereby this is a provision in furtherance through section 17 subclause 1 subclause G. So, what has been mandated under section 17 subclause 1 subclause G, that has been logically extended under section 20, which hit hard and which adopts the strategy for the enforcement and compliance of the prevention and control of air pollution law in relation to vehicular pollution, in relation to emission of the emission from the automobile. As we have said that there are three sections which are to be important, that we must take note of section 17(1) subclause G, where the state board has empowered to lay down the standards for emission from the automobile. On the other hand, this law of the Motor Vehicle Act is also equally important because it says that the state government, in consultation with the state board, gives such instruction as may be deemed necessary. It means it confers a blanket application of the Motor Vehicle Act of 1939, which has been amended in 2018. Then we see that the government or in matters of enforcement and compliance and enforcement of air pollution law. Besides the declaration of air pollution control area, hitting the industrial sector is the one thing. The another aspect happens to be the emission from the automobile, where it take resort to the massive standardization and standard setting which has been laid down under section 17 subclause 1 subclause Z, and in furtherance to or in compliance to what has been said under section 17 subclause 1 subclause G, section 20 also applies its blanket application of the Motor Vehicle Act. Then the authority, notwithstanding anything contained in the act or the rules made therein, is bound to comply the instruction. So what we see that section 20 is also very important because it tries to locate a different source of the vehicular pollution into the domain of air prevention and control of pollution in matters of enforcement and the compliance. Then we will see that how the government of India has come out with a national ambient air quality standard in 1994, and again it has come out with the National Ambient Air Quality Standard, which has been revised in 2009 and which lower the permissible limit and make a standard uniform across the nation about all kinds of ambient quality standard. Thus, we see that whether it is 1994 or 2009 ambient air quality standards, both culminated into a kind of a distinction between the and especially the amendment which has been suggested in 2009 have blurred the distinction of between the industrial and as well as the residential. So that is the purpose of the amendment in having a national ambient air quality standard. We can say with certain certainty that ever since the Air Prevention and Control of Pollution Act 1981 was promulgated and applied, it has been in a continuous stage of reforming the air quality by setting the standard, a National Ambient Air Quality Standard 1994 and National Ambient Air Quality Standard 2009 are indicator to this effect, which have tried to see and eliminate the distinction between the industrial and the residential zone, and it applies across the board the entire standard which has been set in 1994 and 1990, 2009. Having said so, now the question arises that in consonance with or in line with or as a natural sequel to National Ambient Air Quality Standard 1994 and 2009, that we see the National Air Quality Index of 2014, which have launched at least 8 pollutant under its scope, purview and the ambit. It starts from PM 2.5 micron, PM 10 micron, then it talks about NO2, SO2, CO, O2, NH3 and PB, and then we see that the enlargement of the parameters of declaring that parameters of declaration of national air quality or national ambient air quality standard by enumeration of the 8 categories of the air pollutant is something in consonance with or something it is said to be in try to touch upon the World Health Organization guidelines, though it is said that Indian standard are slightly less stringent in compared to the standard which has been in practice or in vogue by the World Health Organization guidelines, and it is not comparable to the international norms and standard. Nonetheless, taking together the National Ambient Air Quality Standard 1994 and taking together the National Ambient Air Quality Standard 2009, taking together the National Air Quality Index 2014 and its 8 enumeration, and looking at the entire standard setting exercise for the prevention and control of air pollution, we see critically, although it tries to touch upon and come closer to the World Health Organization guidelines and certain international standards and the norm permeated for the compliance. And the lastly, in realization to the fact that it is not as stringent and as rigorous as it happens to be at the different jurisdictions of the world to control and abate the air pollution, then the government has also prepared a comprehensive environmental pollution index which provide certain additional benchmarking for the critically polluted area, including the critically air polluted area. So, in matters of enforcement, having read Section 19, Section 20, having read the National Ambient Air Quality Standards of 1994, 2009, 2014, happens to be a very novel addition to the compliance and the enforcement of the air law. Again, we are going to discuss the same thing which we have already discussed in the Water Prevention and Control of Pollution Act, because both the law have the same typology, and the typology is command and control, and the command and control starts from the very system of the consent mechanism and the conditions which are attached to the grant of the consent, which has been mentioned section 21. It says that any industry prior to its operation must seek prior consent from the state board, and application must include details particular of the industrial plant and processes. It also tries to see the quantities of air pollution emission, and it also examines that the control equipments and specifications are well installed, and it carries a limited sense of environment impact assessment data and look at the hazardous waste. All the enumeration in the consent mechanism appears to be very effective and very good enumeration, but it depends that the conditions which are set into the consent mechanism and the licensing of operation, how far it is going to be controlled by the command and control approach under the Air Prevention and Control of Pollution Act 1981. With this consent mechanism, we see that any kind of a violation of the consent fee appears to be from 250 to 2000 based on paid up capital. So here again we see that it is based on sliding scale of the paid up capital of the company. So there is not one fee, and it is a kind of a graded fee. And the other aspect that the board conduct the site inspection, verifies information, and impose a certain conditions, and those conditions appears for the installation of approved control equipment, chimney specification, height requirement, emission monitoring system, green belt development, and periodic compliance reporting in relation to the realization of the fees, which is ad valorem, which is not a blanket fee, and giving a detailed list of the entire aspects of care and caution to be exercised before granting actual consent mechanism. So, the command and control theory which is applicable, we see that any violation of section 21 result into the fine of rupees 5,000 per day for the continued violation. It also try to see that for any obstruction, damage to the board property, false statement, failure to furnish information, also attract a fine of 10,000, and all these information either happens to be the consent or the conditionality which are attached in granting the consent. And then we see that 60 days notice are required for filing the complaint, and this is a kind of a provision which always talk about that the limited public participation. It means it is all the time the board which can create some kind of the mechanism to bring the quality of the air or the air pollution control and the public who are facing are not given a very liberal kind of a participation, but a limited sense of participation by giving 60 days notice and giving an opportunity to the board that they can seek the compliance, failing which waiting for the 60 days period, only then the public can complain and go to the court of law to bring defaulting industry committing the violation of section 21, section 22 and section 31A to see its proper compliance. And this is what is termed as the command and control approach. Thus, we see that the failure to obtain consent is a very critical requirement, and that requirement is that attract penalties under section 37, including imprisonment, which lead to 1.5 year to 6 year and a fine of rupees 5,000 per day for continued violation. And that typically talks about the command and control approach and the penal provisions. After that, we are going to see the power of directorate, which has been given under section 5 of the Environment Protection Act 1986 and then section 33A of Water Act 1974. The replica of the same power is being created under section 31 of the Prevention and Control of Pollution Act, Air Prevention and Control of Pollution Act in 1988, and that power relates to number one is the stoppage of electricity, water or services. It also talks about the requirement of the installation and of control equipment and the compliance with the standards. Here we see that in case of the Air Prevention and Control Act, that the directives have assumed having a wide scope than that of what the scope which has been mentioned under section 5, mentioned under section 33A. Here the installation of controlling equipment and compliance of the emission standards are also added, but primarily it is twofold. The first fold is that cutting short the supply line, and if the cutting short the supply line of the industry is not working properly for the compliance and enforcement of Air Prevention and Control of Pollution Act 1981, then ultimately as a last resort is the closure, prohibition or regulation, prohibition, and ultimately the sledgehammer manner. The board is empowered without looking for the court of law for any appropriate directive in this regard, can order for the closure under its enforcement of the directive and the enforcement of the power. We see that the application of the command and control approach, which has been applied invariably in the water law and as it has been ipso facto applied in the air law, to what extent it is going to be successful. Therefore, we are going to see that how this command and control approach appears to be very effective. Before we can come to the limitation of the command and control approach, we would like to see some of the case law on the point of control and prevention and control of air pollution in matters of enforcement of the law. So, the first case we are going to discuss, there are a large number of cases pertaining to the industrial pollution, pertaining to the vehicular pollution, pertaining to other kind of the pollution which has been let down like the stubble burning, but here we can find to some of the classical cases to highlight the fact that how the Air Act through the mechanism of the judicial pronouncement have resulted into effective compliance and enforcement. The Karnataka High Court in a case known as Obaiya Pujari documented severe effect of agriculture yield and cause of concern for the public health in Mangalore and Udupi district, and then the stone crushing operations which are being carried out in two places have led to the deterioration of the breathing or the ambient air quality, and people have complained some public health issues pertaining to the bronchitis, alveolitis, fibrosis and tuberculosis, and so much so the cancer. In this case, we see that the Karnataka High Court directed for compensation to pollution victim within 2 months, meaning thereby again we see that this case resulted into the polluter pays principle, and we see that the non-compliance with cancellation of the license is one thing suggested as an interim measure for non-compliance, and it also talks about establishment of authority to receive application and assess the damage. And once there is a proper assessment of the damages in relation to the diseases like which are lung diseases and certain public health critical issues out of the effect of the agriculture yield, then the High Court has rightly directed and applied. Here, what we can see that we are discussing and dropping this discussion of limitation of the command and control, although that aspect we have already covered in the water law, but for the sake of reiteration and by adding few new principles, we can examine the command and control approach as it has been exhibited in in section 21, 22 and 31, the failure of compliance of these sections, how they are going to be condemned criminally by imposition of fine and imprisonment. Now, having a look of the case of Abhayya Pujari versus Abhayya Pujari's case and looking at the very ratio of the Karnataka High Court judgment, we can say safely that it has not applied the command and control approach. Rather, it tried to see more merit into giving dispensing environmental justice in relation to applying an assessment of damages by constituting certain authority and try to compensate to the pollution victim. So, this is one of the case which try to deter and depart from the very notions of the command and control which is being envisaged under the Act. And the other case on the point happens to be the MC Mehta Bhatkal Lake case, where the Supreme Court mandated the closure within the tourist resort radius an environmental action plan, and it ordered the closure of all stone crushing industry in and around the Aravali range of the forest and the mountains in and around the Bhatkal lakes near on the borders of Delhi and in Haryana. And thus we see that judicial intervention either going to have the closure as a mechanism or having compensation as a mechanism. So, the closure and at one hand and compensation on the other hand is going to have an effective enforcement. A perusal of these two cases reveals the very fact that the court is not much interested to look at the criminal law analogy for bringing compliance and enforcement of air prevention and control of pollution law. And in the subsequent cases, we always see that in the case of Taj Trapezium and the Supreme Court ordered the closure within 20 kilometers of the Taj Mahal monument and created a Taj Trapezium zone where it has resulted into the closure of the chimney because of the marble cancer phenomena of the Taj Mahal, which has defecated and defiled the very image and the importance of Taj Mahal as a matter of seven wonders of the world, and it has called upon the needy to to conduct some of the researches that whether the refinery of Mathura, whether the foundries of Agra, whether the brick kiln industry in Agra, and whether the use of coal and emission of the coal through the chimneys have resulted into the acid raining phenomena, and that acid raining has resulted into yellowish color of the marble cancer phenomena of the Taj Mahal. And then, having realized this issue, it referred to the National Environmental Engineering Research Institute, Nagpur, to conduct a study, and on the basis of that study, we see that the Supreme Court have very effectively created the Taj Museum zone, and order the closure of all industry within 20 kilometers of that Taj trapezium zone to, to protect the heritage. Here we can see that how air pollution control law, as we have seen in the definition of the property, and then it is a kind of a property, it's a kind of a heritage, it's not a kind of an environment, it's not a human being, it is not plant, it is not other living creature, but Taj Mahal case is a very leading case and giving this impression that the Indian environmental law, be that water law or the air law specifically on the point, have given rise to a kind of a jurisprudence which extends its arms not only to human being, not only to plant, not only to other living creature, not only to other entities of the environment, but it has given the concept of property, which is mentioned under section 2A, and it has been reflected under section 2B of the Air Act, and protected the heritage of the Taj Mahal by declaring the Taj trapezium zone. Having discussed this aspect, we can see that the enforcement and compliance of the Air Prevention and Control of Pollution Act, though it appears to be a very gigantic task in a country where the sources of pollution of the air happens to be multifarious, nonetheless, we have seen that there is a constant endeavor to make standards of national ambient air quality by refining it and trying to touch the international norms and the World Health Organization norm in matters of bringing the compliance and enforcement of Air Prevention and Control of Pollution Act. With this, I thank and I wish you a happy learning.